Welcome to Blockchain Law TV. I'm your host, Anki Kwan. I'm a California lawyer, and in this episode, I wanted to talk about the SEC's recent case against a company called Gladius Network LLC. In this case, Gladius voluntarily reached out to the SEC because they thought that they were not in compliance with the US securities laws when they did their ICO. Gladius did their ICO in 2017, shortly after the DAO Report was published. If you don't know what the DAO Report is, it's an investigative report that the SEC published in late July of 2017, and in this report the SEC warned companies doing ICOs that if they were offering and selling securities, even if this was based on blockchain technology, they have to either register with the SEC or qualify for an exemption. What this means is that you have to register. So this is the process that a company goes through when it goes public, and this is a really expensive process. It costs $1 million or more, and it's also extremely time consuming, and you have to wait for the SEC to approve your registration. What most startups do instead is they qualify under an exemption, and that's the way that they raise money when they sell securities. But Gladius neither registered nor did they qualify for an exemption. And because of this, they were in violation of the US securities laws. They reached out to the SEC because they did want to come into compliance. The SEC investigated them and they cooperated with the investigation. They also agreed to offer their investors a refund, to register their securities with the SEC, and to file periodic reports with the SEC. Because they were proactive in reaching out to the SEC and in taking these measures to both protect investors and to come into compliance with the law, the SEC decided that they weren't going to fine Gladius. Compare this to a case last year. Last year, the SEC went after two companies called Paragon and Airfox. And like Gladius, Paragon and Airfox did an ICO after the DAO report had been published. Like Gladius, Paragon and Airfox were successful at raising money with their ICO. They also didn't commit any fraud nor do anything fraudulent in their ICO. So like Gladius, the only thing they did wrong was they didn't register with the SEC, nor did they qualify for an exemption from registration. And because of this, Paragon and Airfox, they were also in violation of the law. But unlike Gladius, neither Paragon nor Airfox self-reported to the SEC. Rather, the SEC went after Paragon and Airfox, and unlike Gladius, Paragon and Airfox had to pay a $250,000 fine in addition to offering their investors a refund, registering with the SEC, and also filing periodic reports with the SEC. In the Gladius case, the SEC points out that the case illustrates why it's important to self-report to the SEC. In the Paragon and Airfox cases, the SEC said that those cases illustrated a path forward for companies that did ICOs in violation of the law, but it wasn't clear if that also included paying a $250,000 fine. In the case against Gladius, it suggests that if a company self-reports to the SEC, perhaps the SEC won't fine that company, or maybe the fines will be less than it otherwise would be. But if you are thinking about reporting yourself to the SEC, it's highly recommended that you seek legal counsel first before reaching out to the SEC. Another thing that is interesting about the Gladius case is that the SEC once again makes a distinction between pre-DAO ICOs and post-DAO ICOs, and it emphasized that Gladius did their ICO after the DAO report had been published. This suggests that the SEC may only take enforcement action against companies that did their ICOs after the DAO report had been published, rather than going after all ICOs in general. I hope you found this video helpful. If you did, please share it. Thank you so much for tuning in, and I hope you have a fantastic day. Bye!